In the meantime, organized labor may be attracting the wrath of the court if it goes ahead with the planned strike. Attorney General of the Federation and Minister of Justice, Lateef Fagbemi, insists that the order of the National Industrial Court of June 5th stopping labor from embarking on strike still subsists. Fagbemi, a senior advocate of Nigeria, in a letter to the lawyer to the NLC and TUC, Femi Falana, another senior advocate of Nigeria, argued that the plan by both labor bodies to embark on an indefinite strike from next week was in violation of the order and a disregard to the dignity and integrity of the court. The AGF urged Falana to prevail on his clients to respect the order of the court and allow room for ongoing negotiations between the parties on how to address the challenges associated with the fuel subsidy removal. And of course, to discuss this further, I am being joined on the news by a labor law expert, Ireoluwa Ogntuase. Thank you so much for your time.
Thank you. Thanks for having me. I hope you can hear me.
Yes, very well. Now let's get straight to it. There seems to be some sort of, well, I call it legal knot here. A court order insisting that labor does not, embark on the strike, and labor's constitutional right to actually protest. How can you, of course, shed more light on this for better understanding?
Okay, indeed, I would agree with you. It appears to be a knotty issue truly. And why am I saying this? Strike is guaranteed under Chapter 4, Section 39 of the 1999 Constitution. And if we also look at it, it's also guaranteed under Convention 87, 1950, which is the freedom of association and protection of right to organize. And if we also look at Convention 98, 1949, which is right to organize and collective bargaining, all these are international best practice. They are ILO convention that Nigeria has already subscribed to. But let's now bring all these laws within the context of what is happening right now. And if we look at it, we'll recall that on the 5th of June, 2023, there was an order by the National Industrial Court. The order was actually an interim order, which was granted pending the determination of the federal government's motion on notice for interlocutory injunction, restraining the Nigerian Labour Congress from proceeding on strike. Now, if we look at this, it's going to throw up a lot of issues. And the issue that will throw up is this. In the first instance, if we consider Order 17, Rule 14 of the National Industrial Court Rules 2017, it appears that when we have interim orders that are being given, ex parte, is going to last for 7 days. So the issue is, can we still say by the provision of the rules and by the principle that was enunciated in the case of Otoye against Central Bank of Nigeria, a case that was reported in 1989, that the order of the court is still subsisting now. Now, that will determine on the basic wordings of the particular order. Unfortunately, I'm not privy to that particular ruling, so I wouldn't want to jump into conclusion. But of course, I will say that if the wordings of the ruling is that the order for interim injunction is granted pending the determination of the motion on notice, and the motion of notice has not been determined, I would think that it may be contemptuous, particularly contempt ex fasciculi, for the Nigerian Labour Congress to proceed on strike. Now, the second issue I would also now want to say is on the issue of the parties. With respect to the first order that is being given, is Trade Union Congress a party to that particular case? If Trade Union Congress is not a party to that particular case, because, in this instant case now, I understand that it is a joint effort, combined effort by the Nigerian Labour Congress and the Trade Union Congress to proceed on strike. So in the first order given by my Lord, Honorable Justice Anui, on the 5th of June, 2023, if the Trade Union Congress is not a party to that order, then it raises an issue of privity, that was well enunciated in the case of Adegboye against Dapo. So those are issues that may interplay in this particular situation. And that's why I quite agree with you that it's a knotty issue.
All right.
I'm very sure that being chief advocate of Nigeria, they will argue it out.
All right. Now, still as a follow-up to that, do you think that the labor unions actually have a sufficient case to embark on this strike action in spite of the ongoing negotiations with the federal government?
Well, I understand something quite clearly when it comes to the issue of negotiation. Negotiation cannot be ad infinitum. In as much as I will encourage negotiation, as one of the best practice towards resolving a particular trade dispute. We also need to understand that negotiation, a timeline should be put into it. And Nigerian Labour Congress is embarking on this strike because of their perceived feeling, and of course, justifiably so, that the Nigerian government is not very serious with that particular negotiation. Timeline has been given without being fulfilled. Proposal has been given without being complied with. So, in as much as I would say that negotiation should not be ad infinitum, I would also say that the federal government should come out and they should be very serious, with the negotiation that the NLC is being making. It's not something that should be done, wholesale. It's something that can always be divided and staggered. It's just seriousness and transparency.
I would want to take it up with you on that word you used, the seriousness. What are the pointers for you to, consider that, okay, from the point of the government, they are beginning to sound or look serious? What are those pointers, we should look out for? And also, from your standpoint, particularly from a legal arm, what do you suggest as a way forward?
Okay, I will answer your first question, then to the second. With regards to the standpoint, I think government should come up with practical solutions. Now, what is the demand, or what are the demands of the labor? They are saying that they should provide policies, practical policies, in order to show that, the removal of subsidy, the effect will be reduced on the citizens. Now, the question is this: has government come up with any policy? Have they come up with an attempt to implement these policies? For me, I don't think so. So in this light, I think that the Nigerian Labour Congress may be right in that respect to think that government is not serious about it. But with regards to the legal standpoint, how can it be resolved? I will need to make reference to the fact that the matter is already in court. And to the extent in which a matter is already in court, I think it may be a disrespect, to the judiciary and to the court for Nigerian Labour Congress to proceed on that particular strike. Now, we need to look at some provisions of the Constitution. Now, Section 6 of the 1999 Constitution is already clear as to giving the National Industrial Court the power to adjudicate. And also, we also need to remember Section 254C of the Third Alteration Act of 1999 Constitution as amended. And again, talking about the ruling specifically given by the National Industrial Court, we also need to look at Section 287, subsection 3, that makes the ruling and the judgment of the court enforceable on the parties, to which the ruling is being made. So is National Industrial Court now saying that the ruling of the court is not enforceable on them? To the extent in which they cannot separate the ruling in this instant case from themselves. If the ruling is binding on them, then they're supposed to comply with the ruling, else it will be contemptuous. But again, one thing we also need to consider is the transparency of the federal government raising the issue of the ruling. Because if who comes to equity must come with clean hands. If you are coming to equity, you cannot come with your hands soiled. Federal government over time has always also been seen, not to comply with the ruling of the court. So what is the morality of now raising the issue now? That's the question that is yet to be answered.
All right. Thank you so much for your time.
Thank you for having me.